All right, welcome to AI and the future of copyright politics. So 2 years ago, we did a conference analyzing some of the very challenging doctrinal questions at the intersection of general artificial intelligence and copyright law, notably focusing on whether training generative AI is a fair use and whether AI-generated creative works are copyrightable. Since then, more than 50 high-stakes copyright lawsuits have erupted in the US alone over these issues, and the stakes are enormous. The potential statutory damages in these cases run into the hundreds of billions of dollars. The remedies include the destruction of large language models. There are apocalyptic stakes on the table, even for the biggest AI companies. We're still in the early days of these cases. We're still trying to understand how copyright law and AI will interact. However, today, for all we don't yet know about the law, one thing we know is that that has really changed is the political salience of artificial intelligence. AI has become a topic of widespread debate and focus in both our national and international political arenas. The White House recently declared that the United States is in a race to achieve global dominance in artificial intelligence, an industrial revolution, an information revolution, and a renaissance all at once. AI has become a ubiquitous and often divisive social and cultural phenomenon, and these dynamics are now bound for copyright law. Copyright litigation has laid bare divides between creative laborers and industrial rights holders, between tech companies and their users, and even between the branches of the US government, as everyone impacted by the onslaught of AI scrambles to leverage the copyright system to capture the benefits and mitigate the harms. But the battle over AI is scarcely the first time that copyright and technology have clashed. So back when I was a student here at Silicon Flatirons, things used to get really bad at our February conference. In fact, things got so bad that in 2011, then public knowledge president Gigi Sohn gave her famous "Can't we all just get along" speech, highlighting some of the rhetoric that happened. The MPA had accused Gigi and Fred von Lohman and others for being professional apologists for online theft. Gigi responded and said, "Facts don't matter to an industry that consistently overstates the cost of online infringement, ignores empirical evidence, and refuses to reveal data on which their evidence is based." And then our old friend Preston Patton from Disney said, "The thing I love about Boulder is that at 10,000 feet, everything Gigi Sohn makes sense." Now, in defense of Gigi's accusations that the content industry was not empirically grounded, Boulder is only about 5,400 feet. Nevertheless, how far have we come in 15 years since the battles around SOPA? How far have we come since 1998 when the Digital Millennium Copyright Act was passed? How far have we come in the half century since the passage of the Copyright Act of 1976? Our first panel will try and put into some historical context just how the fights over AI measure up in the copyright battles over new technology that we've experienced over the past half century. Does AI's arrival portend a remarkable new shift in copyrights politics, or is this just another copy fight? The long-running copyright battles that predate AI also haven't gone away, and so our second panel is going to talk about AI's arrival and what its political impact means for long-standing fights over fair use, the anti-circumvention measures of Section 1201, copyrightability, and other issues. And we're going to have veterans from fair use battles ranging from remix, reuse, and fan fiction, to creative labor and unionization, to consumer protection, repair, and competition, and even fights over McDonald's McFlurry machines. What does AI mean to these battles? What does it mean to the lawyers and advocates that fight them and the communities that they work with? Okay, First, we are lucky to have someone with us today who is a true veteran of copyright's intersection with technology. Pam Samuelson is the Richard M. Sherman Distinguished Professor of Law and Information at the University of California, Berkeley. Since the 1970s, when it comes to copyright and technology, Pam has been on the forefront of conflicts, from the copyrightability of computer software to safe harbors for internet providers, to infringement and fair use questions about every technology under the sun. From the Betamax to AI, Pam has seen it all and has played a critical role in informing generations of policymakers, judges, advocates, academics, and students. Pam is one of the leading scholars on copyright and technology in the United States, and I think the world, and I don't think that is overstating it. And there's really no better person to help us situate our current AI moment in historical context. So further ado would be warranted, but without further ado, Pam Samuelson.
Well, it's a pleasure to be back in Boulder at University of Colorado Law School, and thanks for the opportunity to participate in this discussion. And I want to start by talking about some of the disruptive technologies and the politics of disruptive technologies from the past, and then think a little bit about to what extent generative AI is similar to and different from those disruptive technologies. I'll go over some of the cases that have addressed the training data issue, which seems to be the big kahuna in these lawsuits, and then talk about the politics of generative AI, which is, as Blake was just saying, it's a little bit different than the ones that we have thought about before. And I'm going to try to also talk a little bit about the collective licensing idea, which is very attractive, right? The idea that, hey, these guys should be able to do training on data that will give us all these generative AI things, but compensation would be a good idea. So I see that it's a really attractive idea. The question is, can it work? So I want to point out that the idea that technology threatens copyright is not new. So here is a quote from someone I'll reveal in a minute. Copyright today is under stress. It's also under attack. The stress arises primarily from the rapid succession of marvelous new machines, miraculous enough to delight Jules Verne for copying and in new ways enjoying protected works. They are for this reason a boon. By the same token, unauthorized copying of print, sound, and cinematographic works has become epidemic. Copyright owners' control has weakened, and the domestic and international traffic in piratical copies of films and records has risen to flood tides. And if the source of the stress lies in rapidly changing technologies, and if the political force of the attack draws from commercial and non-commercial self-interest, the assault weapon is the notion that some proof of harm is a necessary condition for protecting a class of creative industries. Okay, so that just sounds pretty relevant, right? That was from 1982, and the technologies that were of concern to David Ladd, who was then the Register of Copyrights, was unlicensed photocopying of journal articles, videotape recording machines such as Betamaxes, and home audio taping of sound recordings. Okay, these were the things that they were really, really upset about at the time. There was a fair amount of commentary that says, hey, these things are fair uses, they're not really harming any copyright markets, and so everything is going to be fine. And David Ladd basically said, no, these technologies are really causing lots and lots and lots of harm, and they're going to devastate copyright industries. And I just think that sounds familiar, right? We've seen this kind of thing before, and so let me just take you briefly through the history. And I think I'm going to concentrate first on the Williams and Wilkins versus United States case, because that was this case decided in 1974, I think, involving publishers suing the National Institutes of Health librarians for making photocopies of journal articles for researchers who were using the NIH research facility. And by a 4-3 decision, a court of appeals decided that that was fair use. Because it was a split vote, the publisher petitioned for a Supreme Court review. Supreme Court took this case and affirmed the lower court ruling by a 4-4 decision. So we are one vote away from the idea that you have to pay for every photocopy that every researcher might make, that everybody might make. You know, the pendulum changed a little bit with the Texaco case, which held that it was unfair for commercial researchers to photocopy articles without paying. And so the Copyright Clearance Center became the licensing entity for that kind of thing. The Copyright Clearance Center also then became the licensing entity for course packs. Some of you may remember what a course pack was. Today we all do it online, and the Cambridge University Press versus Patent decision showed that even though posting book chapters on a course reserve seems like it's a pretty similar thing to course packs, which were photocopies, the publishers mostly lost the Cambridge University Press case. And so fair use for educational purposes became much more accepted, I think, at least among the federal courts. Now, the politics of photocopying sounds so quaint today, okay? I'm telling you, this was war. This is absolute war between especially the educators and librarians who wanted broad exemptions for educational research uses, and publishers and author group wanted everything to be licensed. What did Congress do? It kicked the can down the road by saying, we're going to leave this to the vagaries of fair use and to litigation that happened thereafter. But it actually was important, I think, that this 1970s study by the National Commission of New Technological Uses on Copyrighted Works, that is to say, CONTU, did a study and basically said, publishers doing fine. And so we don't really think that any additional legislation or a licensing mandate would be necessary, but they were actually hoping that Copyright Clearance Center would actually evolve into a licensing entity for pretty much all photocopying, and that didn't really happen. Now, home taping of sound recordings and of television programs was also highly controversial, and Universal basically said every time people use a videotape machine to watch a program at a later time, that's an infringement of copyright, and Sony is contributing to that infringement because they know that people are going to use the VTR machines to make copies of things. And the Supreme Court's decision was once again seriously split, right? We were one vote away from even making time shift copies of television programs was unfair. So that case was decided in 1984, and soon thereafter, digital audio tape machines were about to enter the market, and the recording industry was really, really worried about that, and so brought a lawsuit to challenge that, even though DAT machines would have substantial non-infringing uses, there was an argument that the RIAA would probably win this one because most people were using the Betamax machines for time shifting purposes, and if you use a DAT machine, you're basically using it to basically have a copy, right? Consume a copy. So the Audio Home Recording Act was passed in 1992 as a compromise to kind of settle the Kahn case. Two things are noteworthy here. One is that while the Sony decision was pending, Congress basically had bills for and against the time shift copying or home copying. And the politics was so intense that if one of the people who sponsored one of these bills wanted to have a discussion about it, other members of Congress would get up and walk out so that there wasn't a quorum, so that they were never able to really have a full discussion of that. The Office of Technology Assessment, which used to do studies to inform Congress about what's going on, OTA basically said 4 in 10 Americans above the age of 10 made home tapes of music. And so as much as the RIAA wanted to make everything licensed, it was like, it's going to be hard to convince the American public to do that. So the Audio Home Recording Act was a kind of compromise, right? It was like there was a non-commercial copy exemption, but it also was going to tax the DAT machines and tapes, basically, to put money in a fund which copyright owners could then draw from. But the computer industry successfully lobbied for an exclusion of hard drives, and so technology bypassed the DAT regulations in the Audio Home Recording Act. Now I'm going to talk about politics of internet first, because what we had in the mid-1990s is a report that basically said, hey, there is this internet and easy to copy and easy to distribute, and piracy is going to happen. And so initially, the Clinton white paper said online service providers are strictly liable for user infringements. They were not able to sell that at the International Treaty in 1996. But there was a big struggle that led to a grand compromise in the Digital Millennium Copyright Act. So the copyright industry's got very broad regulations about tampering with technical protection measures and copyright management information, laws that are largely invisible to the rest of the world. But they compromised on the safe harbors for online service providers, so that until and unless the online service provider had information about exactly where there was an infringing file, they didn't have any responsibility to take it down. And plaintiffs in these cases have tried to narrow safe harbors, largely because the tech industries, they think, have contempt for copyright. And there's been sort of efforts to chip away at them and occasional efforts to pass new legislation, but that hasn't worked either. So we all know that peer-to-peer file sharing actually was a very big deal. And the laws that were on the books actually didn't really address it very well. But at least Napster and Grokster were eventually shut down. And there's a case pending before the Supreme Court right now in which Cox was found liable as contributory infringer, and Sony Music was able to get a $1 billion statutory damage award for the works that were at issue. And the question that the court is going to have to address is, is the failure to terminate accounts where there are more than 3 infringement notices that have been received. And many of the accounts that are affected here are hospitals, military barracks, universities, and other institutions, so that terminating the accounts basically would have collateral damage for innocent people, and how much should that matter? And so that's kind of the thing that's going on there. Now, mass digitization, in the interest of time, I'm not going to talk about that, but the fact that the mass digitization for millions of books were found fair use was a very big development, and not one to be expected. And there was, again, an effort to end that particular litigation through a collective licensing regime. Court basically disapproved it, so the fair use case was decided instead. And the Copyright Office tried to get a collective license scheme to do the same thing, but didn't move forward on it because the responses were negative. So quickly, here are the lessons that I at least derive from the disruptive technology cases. Whether the challenged use is affecting markets for the copyrighted work, are they supplanting demand for the original? That's going to be a very big factor. Speculation about harms is likely insufficient. Just because a large number of copies have been made, that doesn't mean there's any harm to the market. And there is an effort to sort of say, let's look at very carefully at what the market harm claims are, and market failure might actually mean that there isn't harm if you can't form a market that basically will cure that market. And courts have also recognized the kind of circularity problem with, right? So the circularity problem is, I'm a plaintiff, you didn't license something from me. Because you didn't license it from me, that must mean that you harmed my market because I have now an interest in a license. And courts have basically said, that's kind of baloney. Okay, so I think the biggest difference between the kind of the disruptive technologies of before is that they allowed people to actually make consumptive copies of works, to basically be able to have a whole copy of a work and basically consume it for its copyrighted expression. And generative AI, at least when they were using works as training data, is more like the Google Books cases in that the uses are, are non-expressive. That is to say, the uses are analyzing the relationship among words in text and images in the course of training. And I'll talk about the pirated books issue in just a minute. But when I wrote these slides, which was like 3 days ago, there were 56 lawsuits, there are 59 now. And fair use is the main defense. And most of them are class action cases, but there are some very notable non-class action cases, and so far the number of settlements is pretty small. But the fair use argument runs for the plaintiffs and for the defendants kind of like this. And I'll basically say that the Ross intelligence case that I'm about to talk to you about buys the plaintiff's theory, and the Kadri and the Kadri and the Bart's cases, for the most part, by the defendant's theories, okay? But let me run through them briefly for you. So the purpose of the challenged use is always a really important factor in fair use cases. And if it's a commercial purpose, then that usually cuts against fair use. Non-commercial purposes are more likely to be fair use. And the plaintiffs basically look at the exact copying, probably multiple times in the training data context, as you're not transforming them to make anything new, you're just using the work as a work. And insofar as there has been downloading of pirated books, I'm sure it's not a big surprise to know that there are millions of pirated books available on certain sites in the dark web. The nature of the copyrighted work, well, all the plaintiffs are going to say, hey, my stuff is really creative, it's close to the core of copyright, and that should cut against fair use too. The amount, you're making copies of the entire works, and sometimes multiple times, and the outputs compete with our work, and we're willing to license this stuff, but you haven't tried to get a license from us, and therefore it's unlawful. Okay, so that's what the plaintiff's theory is. The defendant's theory is, hey, we're doing something highly transformative, right? as the courts have understood this concept of highly transformative. It is when you're doing something for a very different purpose, right? So when an author wrote a book, they did it to express their ideas and to build a world. And when OpenAI basically trains on that, they do it for a very different purpose, right? Then highly transformative because of the nature, because of the different purpose. And the generative AI defendants basically say, look, we don't care about your expression at all, Ms. Author. We only care about works as data, and we're only like basically analyzing them. And most of the works that are used as training data were voluntarily posted on the internet, obviously not the pirated books, but let's leave that aside. And the amount that I do it is reasonable in light of my transformative purpose, and the outputs don't infringe or supplant demand for the original, and licensing markets are impossible. Okay, that's kind of what the kind of the short version of the arguments look like. So Thomson Reuters is the owner of Westlaw, a computer database that many of you are familiar with. And Ross is a artificial intelligence company that essentially was able to get 25,000 Westlaw head notes from a third-party subscriber to Westlaw. Ross used those things to train the model, but the AI system that he developed doesn't embody or output Westlaw head notes. The outputs of his AI system consists of passages from judicial opinions, which, as you know, are not protectable by copyright law at all. The trial judge initially said, hey, you know, we have to take this to trial because you argued this and the other guy argues that. But then he changed his mind and decided to rule against the fair use defense. That case is now pending before the Third Circuit. That decision came down before the Bartz and Kadri decision, and it will be interesting to see how the Third Circuit grapples with that. So Bartz and Kadri are book authors. They sued respectively Anthropic and Meta, and they asked both the defendants asked for a ruling on fair use, and in June both did. Now, Judge Alsup actually beat Judge Chabria by 2 days, and I'm sure Judge Chabria was like really unhappy that he got preempted by Judge Alsup. But Judge Alsup actually divided the case into 3 different buckets. So insofar as the question of making copies of works for the purpose of training models, Judge Alsup said that's quintessentially transformative because of the different purpose. He thought the second factor, the nature of the work factor, actually did favor Bartz, because you use books because books are expressive and they're well constructed. So that cuts against. But then he says it's necessary to copy entire works for a transformative purpose, and you're not supplanting demand for the book, so there's no harm to the market. I think one of the most significant things about that decision was Judge Alsup's conclusion that authors are not entitled to control licensing their works as training data, period. Now, whether that would be upheld on appeal, we don't know. But that's his ruling. And then he said, you know, if you bought actual published books and then you digitize their contents, that's also fair use to do for training data. But you use pirated books? Now, Anthropic, you have to say, they downloaded 7 million pirated books. 7 million is a big number, and Judge Alsup didn't think that was fair. And so I'm sure you've read that Anthropic settled that lawsuit, or has sought to settle that lawsuit for $1.5 billion for certain books within the pirated books case. So the Kadri decision comes down pretty similar, actually, to the Bart's decision. Again, highly transformative. And so even though it's commercial, because it's highly transformative, that doesn't count as bad. Again, books are creative works, so that cut in favor of Kadri. The market effects factor was a really significant part of that particular decision. So Kadri said, hey, I've lost some sales. And the judge said, look, Meta showed that its output filters prevent big chunks of expression from books to be out there. And like Judge Alsop, he said the lost licensing revenue theory was one that the plaintiffs are not entitled to monopolize, but Kadri failed to plead or offer evidence of what the judge called market dilution. This is a concern that AI technologies will be used to flood the market with competing works and undermine incentives for human authors to be able to do it. And he predicted that if other plaintiffs actually were able to plead that and provide some empirical evidence that fair use defenses would fail. So cases are really similar in many ways, but also different in respect of the pirated data issue. Judge Chabria in the Kadri decision said, you know, the fact that you use pirated books to train doesn't make any difference at all. Whereas Judge Alsop says, oh, definitely not fair use. And Judge Alsop thought that the market dilution theory was science fiction. And so the market dilution theory captured the intention of Judge Chabria and Kadri, and said that even if they're not direct substitutes, they're indirect substitutes, and it doesn't matter that the outputs are not substantially similar. Now, the politics of generative AI copyright so far have been less intense, actually, than in some of the earlier fights that I've talked about. Congress has held, I think, 3 or 4 hearings. The FTC issued a report. The Copyright Office has issued 3 reports, and it was the report that the office released in May on training data, fair use claims, which endorsed this idea of market dilution as a kind of copyright harm. And then the register got fired the next day. So, as you may know, the register's claim is actually that Trump didn't fire her appropriately, is now before the Supreme Court. So this is actually a kind of an interesting place where the Trump administration and the tech industry are like gung-ho about fair use for generative AI uses of copyright works. And unlike with some of the other cases that I talked about, usually it was like journal articles were the publishers. And the recording industry was about the DAT copies. And the motion picture industry was upset about the videotape recording machines. Now everybody's upset, okay? So there isn't a single industry sector that isn't at least a little bit exercised about it, but you know, whether this will prevail or not, again, remains to be seen. Now I wanna actually sort of spend a last couple of minutes on collective licensing, because as I said at the beginning, boy, it sounds like an attractive thing, right? If we think that the fact that 180 million people are registered users of OpenAI and millions of other people use the other generative AI systems, you're gonna say, well, you know, the public seems to think this is a good thing. So maybe it's a good thing that they use data to create these models and are able to generate stuff, but isn't it fair that they get some sort of compensation? So there are 4 different ways that this collective licensing could potentially be achieved. The Copyright Office and most of the copyright industry groups basically said, Voluntary collective licensing, oh, what a good idea. Legislation to create a compulsory license could be possible in another era. Congress is completely dysfunctional. There's no way that this is going to happen. Class action settlements, the failure of the Authors Guild versus Google settlement really suggests that that's not going to work so well. And a court could order some collective license in successful infringement lawsuits, but that remedy could only apply to the people who are before the court. So it's not so easy to kind of get this. So my sort of questions are, who do you get permission from? Turns out that everybody in the world who's posted content on the internet their data is being used as training data. So do we make everybody able to get this stuff? And also the ownership information about stuff that's on the internet isn't so easy to do. And with respect to even publishers of books and authors, you have to look at every single publishing contract to find out, or is there, if it wasn't in contemplation at the time that the publishers and the authors agreed, does that mean that it was reserved to the authors? And besides which, the authors don't have data. The publishers have the data. And what do the generative AI companies need? They need data, right? They don't think they need rights. They think they need data. Also, now in Europe, there are lots of proposals for collective licensing that would happen through collecting societies. But the United States, except for the field of music, has a really, shall I say, undeveloped infrastructure for collective licensing. And so that's a complication. The publishers and the Authors Guild think that they need an antitrust exemption so that they can basically collaborate in pricing to set the prices for each industry for the use of works as training data. And then, of course, if you create a licensing mandate now, that creates an entry barrier, right? So if I did it before the licensing mandate was in place, I get free use, but anybody else has to pay, right? That's kind of seems like that's a concern too. Other efforts to create collective licensing in the US have not been successful. And so I have sort of, I see the attraction of the solution. I just don't know how we get there. So if you have a great idea about it, let me know. I also want to raise a question about nonprofit research. Because everybody sort of assumes that this is all big tech against little author, right? But at Berkeley, and I'm sure at Colorado, there are graduate students and maybe even some undergraduates who are using in copyright works as training data to build their own models because they're doing it as part of their educational experience. And I think it's important to sort of understand that the defendants in these cases has any incentive to push for a distinction between for-profit and nonprofit developers. So I think the fair use argument is better, obviously, for these nonprofit researchers, but if the courts are basically deciding these cases and issue broad opinions, that could have negative spillover effects for the nonprofit researchers. I think we just don't know what's going to happen with that. The other thing I wanted to bring to your attention is what happens to users. Right now, at the time that the Supreme Court heard the argument in the Sony versus Universal case, 5 million American households had videotape machines embedded in their homes, right? And obviously, more people than just 5 million were using those videotape machines. So millions of Americans were affected by that. And Sony's lawyer actually opened oral argument by saying, Your Honors, 5 million American households have these videotape machines in their homes, and the plaintiffs here want to take away all 5 million of those videotape machines. And Universal was planning to get statutory damages for the contributory infringements, which would have amounted to, at the time, hundreds of millions of dollars. You know, the question that Universal's theory was that everyone who copied was an infringer. And the question I'm sort of been puzzling about, well, if OpenAI and other of the generative AI companies have infringed copyrights doing the training data, are the users also infringements by their use of the technologies? Because they're making copies, right? And they're asking for copies to be made of content. And that content might have indirect market substitution effects and therefore dilute markets. And I think we don't know about the answer to this question, but it seems to me if we're kind of trying to have a holistic understanding about what's going on, that we ought to think about that too. So generative AI, only the latest of many technologies to attract copyright lawsuits. Some of the challenges have succeeded, some of them haven't done that. I think people can basically say, oh, look, the copyright plaintiffs in these cases have a point, right? You basically made copies of millions and millions of books. You did it for a commercial purpose, and you're now making money off this, and you didn't pay anything to the authors or the copyright owners, even though their works are raw material on which the systems are built. So I don't think there's a kind of like a simple case either way, but I wanted to lay out the landscape, and we'll have a chance to do some further discussion about this as the program proceeds. Okay, thank you.
What a way to get us started. Here at Silicon Flatirons, when we do question and answer, the wiser rule is such that the first question, and maybe a couple of more, will go to students. And some of my copyright students made the mistake of saying hello to me this morning. So I know where you are in the audience. But first question to a student. We'll take volunteers and then proceed to cold call it. Ooh, yeah, the threats abound here. Emily, I'm going to call on oh, I've got Adam right here in the front. Let's start there, and then maybe I'll go to Emily after that.
Oh, thank you. So I ambushed Professor Reid earlier before the semester started with a very similar question about Cox v. Sony. I know this is not an AI case, but it has profound implications for the AI industry. Could you make a prediction? Would you make a prediction about what you think the Supreme Court will likely do? And plus or negative, how do you feel like that case might impact future developments in AI litigation?
So I think the question that the Supreme Court is addressing is about the scope of secondary liability, right? The question is it enough that by Cox not terminating accounts where 3 or more notices of infringement had been received by Cox and they didn't terminate them, is that a contributory infringement? Now, there was a finding at the lower court that the accounts that had 3 or more of these notices were, quote unquote, substantially certain to be accounts where infringements happened in the future. And so that's where the knowledge comes from, right? So you're materially contributing by continuing to provide service, and you are substantially certain that some infringements are going to happen because you didn't terminate. Okay, that's the kind of core thing. Now, that actually, right, So it's material contribution plus knowledge, and that's the basis on which the $1 billion damage award was made. And you got to say that some of the Cox employees had some, shall I say, not very wise things to say, which came back to bite them in the jury trial that happened. You know, how much was that going to matter to the Supreme Court? Well, I think unlike the kind of the safe harbors that apply for generally online service providers, Cox can't control like who in the hospital is using the broadband facility at any one time, right? And so you have then this possibility that one or a small number of users of a particular internet connection, broadband service, are bad guys, but does that mean, you know, Cox can't do anything, right? I mean, and it doesn't really know that there's going to be additional infringement. So there's a kind of causal nexus issue there. And also, I think very important in the case is that the Solicitor General filed a brief in support of Cox, basically saying that substantial assistance to an illegal act is necessary, and that merely providing broadband service, which is a broad, right, it's like a general purpose thing and has substantial non-infringing uses, echoes of the Sony Betamax case. And so the Solicitor General's brief both says that Cox is not a contributory infringer, and also that the willful infringement finding by the jury that allowed up to $150,000 per infringed work, that was wrong too. That there was not willful infringement. Now, the Solicitor General doesn't always win when it files an amicus brief, but some of you may recall the Twitter versus Tomna case that was before the Supreme Court a few years ago. And that was a case in which the provider of a general purpose technology, namely Twitter, was essentially sued for contributing to the death of the plaintiff's family member because of a terrorist incident. And so the complaint was that Twitter didn't do enough to monitor, take down, and kick off the people who were doing it. And the court decided, I think unanimously, that that was not substantial assistance necessary for secondary liability. So the Solicitor General basically invokes the Twitter versus Tomna case as additional kind of secondary liability thing. And then that then raises the question, what does substantial assistance mean, right? Aiding and abetting and secondary liability, contributory infringement, they're pretty close concepts. And the court, I think, will address that. The briefs in the case are really excellent. So if you're interested in that, I would recommend looking at the briefs.
Pam, can I ask you
The case will be argued December 1st, by the way.
And by the way, we'll be doing a listening party here at the law school for those that want to come in bright and early. Can I ask you a quick follow-up? What do you think about the consequences of the ruling in Cox versus Sony, where we have people's internet connections sort of at stake, versus the consequences of these fair use decisions in general artificial intelligence, where sort of the economics of the AI industry are implicated? How do you weigh the stakes?
Well, I've seen some speculation that whatever the Supreme Court does in the Cox case will have spillover effects, because a lot of the claims against the generative AI developers are contributory infringement claims. And so what happens with those, I think, now most of these cases actually are counting on direct infringement claims, not indirect infringement claims. And there's no question that Cox itself was not making copies. And the difference between consumptive copies, that is to say, copies where I get a whole copy of the whole thing and I get to listen to and watch it as many times as I want. That kind of consumptive copying, which is what's at stake in the Cox versus Sony case, is different from the generative AI stuff because in general, the outputs of the general purpose artificial intelligence systems are not substantially similar to the works that we're trained on. And so the idea that a work that has the same subject matter is now diluted market. Now, how do you decide, right? So if one of the concerns expressed is what happens to people who write romance novels? Now, that doesn't happen to be a genre I really care about. So, if that industry or that part of the publishing industry kind of disappeared, it would not affect me or many of us one iota. But, they're copyright owners, they're authors, they're entitled to something. But how would you know if an AI-generated romance novel, which of the romance authors are getting diluted? Does everybody get diluted? I don't think we have any kind of empirical information that will let us answer that question with any confidence.
All right, continued conversation about romance novels during the reception, but further questions, let's go to Emily. All right, let's go to Aram first. He's got the mic, and then we'll go over to Emily.
Thank you for a riveting talk and a really detailed overview. I feel compelled to push back against one small point, which is the premise that we can all agree that there were massive market harms from P2P in the music industry. And that is a claim that is still broadly disputed in empirical research. And there are several exogenous factors that have been left out of that narrative, which I've detailed in some of my work. So I'm always that guy, and I apologize for being that guy, but this is not a consensus opinion.
Yeah, no, if I suggested that, I misspoke because all of these claims about massive harm are unsubstantiated. The Napster case really came the closest because there really was some empirical data that was presented to the court, but that was a rarity. Usually, it's just they made a lot of copies, and therefore there must be harm.
You spoke a little bit about the possibility, if the plaintiffs win some of these cases, that users of generative AI might be contributorily infringing. If it comes down to that, how do they propose to enforce that, and would the industry survive? Could you speculate on that at all?
Well, I mean, the solution that was part of the Audio Home Recording Act was a tax, right? But it was a special tax, right? It was a tax on the machines and a tax on the tapes that people would use to make copies. So the idea behind the Audio Home Recording Act is that people who had DAT machines that were Audio Home Recording Act compatible would be able to make a first-generation copy of their favorite music, but they couldn't make multiple copies from the same copy, right? That was that was the kind of basic compromise. So the hope was that by putting a little friction in there, because you can only make one copy at a time, that people would not do multiple copies and the recording industry would not fall apart. So that was a kind of a theory at the time, but the idea of taxing and then putting that money into a reserve account of some sort, and then having essentially an allocation to copyright owners, that was an idea. And some of my colleagues in Europe are proposing the same thing, right? Some of them want to put a tax on use of works as training data, but others of them say, look, let's just tax the commercialization of these services, create a big pot of money, and then copyright owners get to get some money from that. Now, when we're talking about billions of works, I mean, kind of hard to see how much, it's going to cost a lot of transaction costs of trying to get, 50 cents to everybody, or, even $50, right? It's like, that's really expensive, and it's not clear that it's really cost effective. On the other hand, I completely understand that it's not very sympathetic to say that, hey, I copied billions of things, and because I copied billions of things and it would be hard to form a market, then I get to have it for free. Whereas if I did a smaller number, I'd have to pay. It's like, that's not very, shall I say, persuasive.
Back.
Thank you so much, Pam. That was really extraordinary and really helpful for those of us who are teaching these cases. So I think this is a pretty pointed and short question. Last year I taught Authors Guild. This year I taught Bart's and Cadre, albeit excerpts. And the most notable thing to me was that Authors Guild, in my reading of it, was largely, the Google Books case was largely justified, or in large part justified, because Google had this pointing function, the information finding function of directing people who were searching in Google Books back to the actual book from which it was excerpting, such that purchases could be made. Why do you think that's dropping out of the Gen AI case transformativity analysis? And do you think that that suggests maybe another possible policy intervention that isn't, having to license with a gazillion authors?
Well, I think one of the questions that I grapple with is the question of, do you treat everybody the same, right? So the general conversation about generative AI, especially about the training data issue, basically is a broad brush. Oh, everything's fair use or everything's unfair use. And I think that's probably not exactly right. To me, for example, visual artists are more at risk of market harm than computer program developers who made their source code available on GitHub for free. The software is got a thinner scope of protection than visual art. I think coders are in jeopardy because of generative AI, but it's not really because of the open source code. And so it seems to me that we're kind of, again, in early phases. All the conversation is like all fair use or unfair use. And I think that what we see just in these 2 or 3 decisions so far is differentiation. So in the brief that a couple of colleagues and I filed in the Ross Intelligence case, right? We basically were saying, I'm not kidding about this. The judge basically said, it's so creative to read through a legal opinion and figure out exactly which parts of the opinion to really highlight as a Westlaw headnote. It's like a sculptor standing in front of a block of marble and trying to decide how to carve it up. And I'm going, I'm sorry, that's not even close, okay? That if headnotes have copyright protection at all, it's super thin, and the interest of people being able to get access to law is a much bigger policy reason why we want to have that kind of thing available. So I think we have to differentiate among different types of things and basically say some classes of authors may be more affected than others. So for example, the Berkeley Center for Law and Technology used to have a visual art firm that we commissioned to make logos for our conferences. Generative AI does a pretty good job, and so that that's an example of something where, but how much is there a causal connection between that? Does that one firm have a claim against the Berkeley Center for Law and Technology, and for what amount of money? I don't know.
All right, I know we've got a lot more hands, but we've got to go to a break. Never fear, we are going to continue in the next panel to react to Pam's talk, and we'll have an opportunity for more questions. We will return at 10:15 Mountain Time for those of you online. See you back then. Let's give it up one more time for Pam.